Welcome to Niger Voice. This morning we want to let you know that Omoyele Sowore has exposed Nigerian government and he has made us know why they are afraid to let Nnamdi Kanu go. He said that Nigerian government is actually finding solace in wasting Nigerian money on the tribe that is not tribal. I want you, if today is your first time of coming across with our channel, we want you to please like our content and subscribe to our channel so as for you to get more of our content subsequently. So in this video, we want to let you know that Nnamdi Kanu has exposed the DSS and he said that they first aim to make some confectional statement. In this video, you will get the full details of what is said about the DSS. Thanks for watching and may God bless you immensely. Keep watching as you get the full detail.
That you cannot try a case that is not triable in a court of law. People who are aspiring for freedom, which is recognized worldwide, is recognized by laws and treaties, is even recognized, I think, by their 1999 constitution, that every Nigerian have a right to associate with whomever they want and express themselves freely. And these are cases that has become a bone in the neck of Nigeria because Nigeria refused to purge itself of a war that was needless in 1967 and that ended in which they themselves declared that there were no victors, no vanquished, or no victor, no vanquished. But the victors continue to vanquish their victims. So I am here to say once again that if there's anybody who has sense in the government, today is the final day to sit down and release Nnamdi Kanu and stop wasting Nigeria's resources on a trial that you know cannot go anywhere. This trial has gone through all the courts of the land, except maybe I think it went to a magistrate court at the point when they first started this charade.
Yes. So what is the implication of today's?
The court cannot adjourn a case in which it has no jurisdiction. The judge has already made an order, a consequential order, that she has recused herself from this trial the last time. So you cannot now assume jurisdiction over a case from which you have disqualified yourself. That is a very simple legal maxim. So, and she also cannot be a judge in her own case or court. She has been indicted by Nnamdi Kanu and the lawyers that she's not fit to be a judge in this case. So adjourning the case is irrelevant. But I guess maybe she adjourned the case indefinitely to allow reason or oxygen to bring it to the brain of the people who are running Nigeria. Hopefully, they will, within that period of time, resolve this matter. I won't even say in the interest of justice, it's in their own interest. Yes, so because the Supreme Court and other courts have resolved the matter in the interest of what is limited justice in Nigeria. Yes.
Thank you, sir.
Thank you very much.
Yeah.
Imagine if a judge say you are my.
That is the complete thing. This is what happens. You can see. They don't want to.
I'm doing my job. That's this man. He knows me very well.
Nobody wants to come out in Nigeria. What is that? That's the problem. Who is that person? Don't have that. Who is that person?
After you say that you're insulting to some people, after you say that you're insulting to some people, don't tell me this one, though. Okay, I'm not telling you this one. I don't tell you.
They sent her to my case so they can release or smoothen the pathway for the husband and the son. They are facing, but it doesn't matter if they're off it. In a corrupt society, that's what happens. They are very, very corrupt. There is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. So, disobedience to superior court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why therefore are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and distinctly that he is no more. That she no more going to try me. Why are they insisting? Why are they insisting? I ask you, I've made their friend. Because they have no case against me. They have no case against me, and they know.
So are we ready? Hey, Kabiru, Abi, 1 minute, Shino.
No. Are you set?
Are you ready, Shino? No, Shino. Okay.
Okay, so you
Yes. Honestly speaking, what happened this morning is uncalled for.
Go ahead.
Actually, what happened this morning is actually uncalled for. You can see how the defendant, Nnamdi decided to represent himself. He asked the lawyers with the legal team that we should stop, that he wants to speak. Because Nnamdi is feeling that Nigeria is not fair to him. He's just a human rights activist agitating for self-determination with reasons. And one expected the federal government to address all those reasons that gave rise to this agitation. Of course, you also discover that some other persons that are having this similar issue within Nnamdi. I'm talking about the offense of terrorism, Sowore from the west, the president of Mieti Allah Kato from the north, Sunday Boho. Their own has been settled. Why is Nnamdi still in the detention? And the people are saying that it's because he's an Igbo. Buhari did it because he's the president. Now Tinubu has come from the west. And this is not good for this country in any way. So we feel that there is still a room for them to withdraw these charges and so that we have peace. Of course, you now discover that the Court of Appeal, non-Court of Appeal is sitting in the whole of Southeast. The judges, the federal judges in the Southeast, judges of National Industrial Court, Federal High Court, Court of Appeal, they are not sitting because of the threats given by some persons saying that there is no justice in this country. So you can see how what Nnamdi is saying. I tried, though as a lawyer, is uncalled for, but I try to see his feelings.
Now, we saw your client use so many unprintable names.
Yes, of course, which I did not consent to. Of course, because what we are, as a lawyer, we have our rules of ethics. And you discover that when we are trying to calm him down, he said that we should sit down and walk away, that we should not represent him again. So he decided. So he's not a lawyer. So, and I think the judge and the federal government understand, because many people have applied to the federal government. Many other persons have applied, has begged the federal government, please use political means to resolve this particular matter, releasing Nnamdi so that we have a peace. So, and now the judge, on the issue of the judge recusing herself, there is a subsisting court order. That's what Nnamdi is saying. What one expected the judge to first of all set aside that order. I hear them say, you give the order, you have the right to set aside the order. And even that to set aside the order, you to have now give way for you to have jurisdiction into the matter. Thank you and God bless you.
So does it mean now no longer represent?
Except he called us and asked us to continue. From what is in the court now, he has, maybe because of today's proceedings, are you going to say, because I have a letter he gave me, and that letter has not been withdrawn. Officially. So if he wrote to me and asked me, I will withdraw. It's my pleasure.
Your name or
Max Sowore is my name.
Thank you, sir.
DSS forced me to make confessional statement under duress. Nnamdi Kanu told the court yesterday. Nnamdi Kanu told the court that it was threatened by an operative of the Department of State Services to make confessional statement under arrest in 2015. Kanu spoke on Wednesday at the prosecution court. He told the witness simply identified as CCC. Like the first two witnesses, 6AA and BB, the third witness told the court that was part of the team of DSS officers who investigated Kanu in 2015. The witness said he and 2 other DSS officers interviewed Kanu on October 21st, 22nd, 23rd, and 24th, and also on November 4th. He said the interview was recorded on video, noting that Kanu also wrote statements after every session. Adeboyega Awomolowo, counsel to the federal government, tendered 2 video compact discs containing the interview and also 3 copies of statements allegedly written by Kanu. Although the defense team did not oppose the exhibit at first, but Erokoro, one of the senior advocates who spoke on behalf of Kanu, later raised an objection. Erokoro said Kanu had just informed him that the written statements were made under duress. The Apple leader counsel told the court that DSS operatives denied the defender's access to his lawyer, threatened to deny him bail, and withheld his daily hours of fresh air recommended due to his health condition. James Omotosho, presiding judge, ordered the conduct of a trial within a trial to ascertain the voluntariness or otherwise of the defendant's statement. Trial within trial. During the trial within trial, the DSS witness insisted that Kanu wrote his statement voluntarily. Erokoro said, asked the witness if they understood the process of detaining a suspect, knew of the officers at the DSS headquarters, and had contact with Kanu in his cell. SCCC said he never entered Kanu's cell, but knew of the gatekeepers who could interact with the defendant. Erokoro said, I put it to you that if any DSS officer named Mr. Brand visited the defendant in his cell to threaten him, you won't know. Responding, CCC said the DSS does not operate like that. During the trial, within the trial, Kanu said, thank you for watching and may God bless you.